Welcome back to Law Talk Moments, a legal program designed to make the complex simple and to promote the practice of law, which I unapologetically consider to be a noble profession. My name is Attorney Rob Caprera, and I'm humbled to be your host again for this program. Our topic today involves a very common and essential estate planning tool, which we refer to as the durable power of attorney. In Massachusetts, it's specifically defined and controlled by Chapter 190B, Section 5-501 and following. For years, power of attorney have been in existence, whether as a general power of attorney where the principal gave to the attorney, in fact, every right and power that he or she might have had, or whether as a limited power of attorney where the principal only gave certain limited powers, such as to sign a tax return or obtain confidential records or sign a mortgage at closing. A problem existed with each basic type when the giver of the power became incapacitated. The question arose, if the principal became legally incompetent so that he or she couldn't give a power, or more importantly, couldn't revoke the power, did the principal giving of the power actually continue? This posed a very legitimate concern because the integrity of the power was now under question. And if it was now under question, it couldn't be relied upon with confidence. Every good reason for putting the power in place was now foiled. Clearly, this was a problem. To solve that problem, legislators thankfully stepped up and created by statute what we now call the durable power of attorney. These are really no different than the previously used general or limited powers of attorney, except they are drafted to survive incompetency or disability. They are made to be durable. Effectively and simply, by adding a special line to the document, it will be treated as durable. What are the special words? Either, quote, this power of attorney shall not be affected by subsequent disability or incapacity of the principal or lapse in time, or, quote, this power of attorney shall become effective upon the disability or incapacity of the principal. If the durable power of attorney contains this language and is signed and dated before witnesses, then it takes actual notice of the attorney in fact or a third party relying on that power to terminate the power. In other words, unless the attorney in fact or a third party relying on the power has actual notice that the principal is revoking the power, if they act in good faith, they can rely completely and confidently on that power of attorney. This takes a substantial amount of guesswork out of dealing with the power of attorney, and business can be conducted with greater ease and confidence. I consider this a good law, and as a longtime attorney who began practicing before these durable powers of attorney existed, I can attest to the lowering of risks and concerns that accompanied these new types of powers. In my estate planning practice, I always recommend that every person making a will also make a power of attorney. It is best practice to get one of these documents in place early because when you might really need it, you'll be too incompetent to sign one. And the alternate remedy at that time would be a guardianship or a conservatorship or both, and they are time-consuming and expensive. So I strongly recommend that you immediately put into your estate planning a durable power of attorney. They are simple and inexpensive, and there is no excuse not to have one. In our next program, we will consider a companion document to the durable power of attorney, that is, the healthcare proxy. I strongly recommend that everyone nowadays has one of these documents in their estate plan as well. So I encourage you all to join me again at Law Talk Moments, where we'll continue to make the complex simple for you. Please like and follow this Law Talk Moments channel. If you like your legal questions to be considered for future presentations, please submit them to www.capreralaw.com. And as always, thank you for listening and take care.